Let's talk about the cases. So there's a really big one I wanted to talk with you about, which is I think the 10th Circuit regarding student visas, which is really a disaster. And now the facts of the case, a guy was accused of rape and the charges were dropped. I don't know the details if it's true or not, but charges didn't continue. So the guy's got the benefit of the doubt, but the consequences for immigration are horrific. Why don't you jump into that and let us know more about that?
Well, that's right. Well, if the charges that would have been all right. I think he probably would have got out of that. He got charged. He went to trial, and he
Oh,
was found not guilty by a jury. And so the problem is that for the 13 months it took for him to go to trial and to get a not guilty, he was out of status. And as you know, and there aren't that many student visa cases on petition for review, but as you know, if you go out of status, you're out of status. And I don't do student visas that much, but my understanding is you can, try and get back in status, and there are exceptions under the regulations, and maybe even Mr. Awuku Asari could have reinstated his status under the regulations if the violation resulted from circumstances beyond the student's control. He actually might have a good argument for that if he could find another university, of course, but he was placed in removal proceedings and charged as removable under 237A1CI, which essentially is the students who go out of status fail to maintain their status. And it gets even more interesting and beneficial for him because in the 10th Circuit, and I'm not familiar with the case, but apparently there's a case called Lee v. Mukasey. Attorney General Mukasey indicates how old that case is. But in that case, it was talking about a different student visa statute, INA 214 M2, which is, I think, individuals who come to attend secondary schools. And in that case, essentially, the 10th Circuit held you only go out of it if you, the non-citizen, have done something to affirmatively go out of status. That's the only time that provision can be applied against you. And in that case, it was if you terminate or abandon. So that's an affirmative act. You have to terminate or abandon under 214 M2 to fall out of status if you're attending a secondary school. And so that argument was made in regards to 237A1C, but the 10th Circuit rejected it. And that was, according to the 10th Circuit, because the statute uses the passive voice rather than the active voice about terminating or abandoning. 237 says a non-immigrant who has failed to maintain. And the 10th Circuit viewed that as saying it's just a description of an event. Doesn't matter why the non-citizen has failed to maintain their student status. If they have failed, then they're screwed.
Yeah.
Harsh ruling, very harsh, of course, for Mr. Awuku Asari, although good for him, he doesn't have a rape conviction.
Yeah.
I mean, it's. I think about that sometimes. It's impossible to make that determination for a non-citizen, right? But would you rather have a criminal conviction, or if you had to pick one, or be removed from this country? I don't know.
I mean, his life, he spent a bunch of money on school. Right. He's getting kicked out. Very difficult to be able to come back in anyway. And he always has to have that police record with him whenever he wants to go travel internationally. It's just like, life got, he always bounced back, but it was really disruptive of his life plan. It's pretty bad, yeah.
To me, no one talks about it, but I mean, 13 months in prison and you're not convicted. I mean, necessarily during that 13 months, the man had no conviction. I mean, to me, that's crazy. I understand that you need to imprison dangerous individuals pending trial, but it seems like a lot of the time the individuals who remain incarcerated pending their trial in criminal court are the poor individuals, and the rich individuals usually get some sort of bail pending trial. So what was he supposed to do? I mean, this is an interesting question. It's complete ivory tower, but I mean, if he had, can you attend class in prison? I mean, can you maintain your student status in prison? Probably not. And that's why he falls within the regulation if he could reinstate. But yeah, it's a rough one, and I think the 10th Circuit recognizes that, but it's a very textual statutory interpretation type decision, which can be very cold sometimes.